Yeah, I am. Thank you.
Okay. All right. And I'm not muted. Our case before us is 2209 Great White Realty Group, the LLC, 1065 State Highway, Route 6, map 36, parcel 184, appeals pursuant to Massachusetts general law.
You're muted.
Sorry.
Maybe it's.
Again,
There we go.
Just don't let them in for a while. Stop muting me. Dated March 15th, 2022, noting the petitioner owner is continuing to use the property as a contractor's yard and demanding it cease and desist all activity and remove all equipment, materials, storage containers from the unit. Petitioner states the building commissioner has no authority under Massachusetts law to order the property owner to cease contractor's yard use where the use is allowed as right in the zoning district under Wellfleet zoning bylaw, and the property is fully conforming. The board for this case will be the board from the last hearing: Mick, myself, Manny, Andy, and Jan. And I wanted to state for the record for the audience, just to get us started, that this is largely a procedural hearing under Massachusetts general law regarding zoning. Massachusetts general law provides that anyone may file an appeal of a building inspector's determination, and the first level of appeal comes to the zoning board. Obviously, we've heard this case many times, and it would be my preference not to rehear the case to the extent that we can not do that. I am going to allow public comment, but I'm going to ask that folks be brief. We have upwards of 20 letters, which will be incorporated into the findings. But unless people have strong feelings about reading the letters, that we probably will not read all these letters. But understand that you have been heard. We have seen the letters. We have all read the letters. And so with that, I will begin. And Mr. Zender, to you as well, I would prefer that we not have a whole rehearing of the case. So if you could just confine yourself to this particular part. Thank you. And you're on.
Madam Chair.
Yes.
Thank you. Good evening, everybody. It's nice to see you all again. I can't wait to see you live, but it'll happen sooner or later. With that being said, I'm really not going to make a presentation. As the chair has indicated, this is a procedural step for us on the way into the land court so that we can consolidate all the legal issues for hearing by the land court. So I'll ask the board, to overturn the building inspector's cease and desist letter. I don't expect that you will, but I won't provide any further argument because I'll just let you get to where you're going to go. And thank you all for being online and hearing this.
Thank you, Mr. Zender. And I think I will also ask for anyone who wants to speak from the audience, probably.
Through you, Madam Chairperson.
Yes.
Should we hear from Attorney Reid first?
Yes, that's what I was going to say. Preferably starting with Attorney Reid.
Thank you, Madam Chair, members of the board. I think that's the briefest presentation I've ever heard from Mr. Zender. I'm sure the board appreciates that. I had planned on saying a lot more, but there's not much to rebut. You have a letter from me dated May 9th. I assume you've all had a chance to read it. I would just like to say that I think the appellant's premise is that once a use is listed with a P on the use table, that's the end of the discussion of whether or not it's allowed. And I would suggest that that's not the case, that the use table sets forth a category of uses, but that's not the only definition of what's allowed and not allowed in the district in the bylaw. He's correct that the legislative body of the town meeting, considered whether contractors' yards should be allowed in this district and decided that they should. And to some extent, that means that the fundamental issues of whether contractors' yards are good or bad is a done deal. But that's not the only decision that the legislative body made. They also incorporated into the table of uses the introductory paragraph 5.2, and they also incorporated paragraph section 6.7, both of which you relied on heavily in deciding not that a contractor's use isn't allowed, but that this particular use at this particular site doesn't meet the parameters of what is allowed for a contractor's yard. That's essentially what you decided. Not that a contractor's use can't be there, but that this particular combination of uses both existing and intended, doesn't meet the limitations that the town meeting imposed on all uses at this site and on contractors' yards in particular. And I think you do have that discretion, and the building inspector did have that discretion. The suggestion that even the building commissioner doesn't have the authority to exercise any judgment about whether or not a use conforms to the definition or not doesn't make any sense. In fact, it's exactly the opposite of what the applicant did themselves. After your decisions in 2021, they went back to the interim building commissioner, provided him with more details about what they wanted to do, answered his questions, modified their proposal until the point that they convinced him that what they wanted to do was a quote unquote contractor's yard. He had to exercise some judgment and discretion in order to decide whether that particular use met the definition in the bylaw. And he decided that it did. And chapter 48, section 7 says he has that responsibility and that power. And chapter 48, section 14 also says that when you are reviewing his decisions, you have the same discretion and authority. So you also had to decide whether what they proposed met not only the category of use, but whether it also met all the other parameters of use that are in the same bylaw. And you decided that it did not. And that's all the building commissioner is now asking to do, or ordering them to do, is to comply with your decision. And he had the absolute right to do that. And you have the absolute right and authority, and I believe obligation, to uphold that decision. And with that, I'll defer what I was going to say. For the rest of it, ask you to please incorporate and consider the points in my letter. I wanted to say to you all, this is important, that we appreciate board and the town standing behind this decision. We understand that you and the building commissioner and town council have many other things to deal with, and that this is consuming a disproportionate amount of your time. But if it's worth having rules like this in your bylaw, it's also worth enforcing them. And we ask you to continue to do that. There are many of our folks online here tonight. I don't know that they need to address you. I know they all want to, because they're as frustrated as perhaps you are about this. But I would echo your comment, Madam Chair, and ask that they perhaps merely note their presence or add anything new if they haven't already had a chance to address you on the issue of the cease and desist order only. Thank you for your time and for your attention.
Thank you. Okay. All right. I guess I will ask if there is anyone else in the audience who feels that, yes, Mr. I know you. I'm sorry. So you're muted.
You are muted.
Oh, he's
There,
on-
can you hear me now?
Yeah, and again, I'm sorry, but you'll have to remind me of your name, sir.
It's Lou Wise. Amy
Yes.
is my wife.
Mhm.
I'm using her computer again.
Okay.
I just wanted to follow up on what David said, not on the merits of this case, but on the whole enforcement issue. And I'm going to be very brief, but I'm speaking on behalf of myself and also on behalf of our neighborhood group, who, as David said, the group is quite frustrated about the current situation. You know, so I'm not going to speak on the merits of the case. I'm going to speak about the failure of the town to allow essentially Great White to continue operating its business on the property in question. Despite the fact that you have now ruled twice against Great White and will presumably, obviously, reject the appeal before you tonight, GW, Great White, will continue to operate without a permit, just as it did when it clear-cut almost the entire parcel and started operations all without a permit. And it will continue to operate with impunity in flagrant violation of the rules in Wellfleet, because we are told the town has decided not to enforce the cease and desist order, which was issued in furtherance of your decisions. Instead, we are told the town will focus resources on Great White's two land court appeals. The problem, I would submit to you, the problem with this approach is that Great White everything within its power to drag out these court appeals as long as possible, that it can continue to operate and profit from its business there as long as possible. Meanwhile, we, the neighbors, are forced to endure the noise and the dust and so forth produced by the operating on the site from morning until evening. Especially affected, of course, are those who directly abut the property and or frequent VR's restaurant, which also abuts the property. I believe that the quickest way and the most efficient way to bring this controversy to a head is by instead seeking immediate court enforcement of cease and desist. A court injunction ordering Great White to cease operations pending the resolution of the pending appeals will protect the neighborhood as the appeals are litigated to a resolution. It will also serve to motivate Great White to resolve the appeals as quickly as possible and might even cause it to cease its operations at this site for good. Quite frankly, as David alluded to, failure of the town to enforce the cease and desist order by seeking a court injunction or even to assess daily fines has caused many in our group, and as you know, it's a large group. There are approximately 100 households in the group, and it's caused many of us to lose faith in the town government and in the system itself. You know, White loses twice before you and yet continues to operate without a permit in defiance of the court, all at the expense of the neighbors. It seems as though we win each battle, but the war goes on and continue to go on unless the order to cease operating this illegal business is enforced. So I guess the way to conclude this is to respectfully ask you folks as a body, and for that matter as individuals, to do anything within your power to cause the town to rethink its strategy and instead to enforce this order in order to protect the neighbors during the process of resolving the court battles that are going to go on for quite a while. We hope that you will use whatever influence you may have in this regard in order to protect our group. Thank you, Madam Chairman.
Thank you. Thank you. Okay. Let's see if I have any more hands. I think then I will turn to the board for any questions. Mick?
Thank you. My stance hasn't changed. I do have to agree with Attorney Reid that as a volunteer on a board, and it's been unfortunate where we have issued some cease and desist before, and they carry the weight of the building commissioner behind them. And I don't understand why this one is being ignored. It really, whether I agree or disagree with the case, the fact that this has been ignored with impunity makes a laughing stock of this board. That's my comment on that. And my stance hasn't changed on anything else.
Yeah. Okay, Andy.
Well, I don't know the answer to the question that Mr. Wise asked, specifically why we haven't sought an injunction, but I will turn this over towards Mr. Zender and ask why his client, well, let me back up. My assumption is that unlike anything else I'm ever seen in law, you've got to go in and get an injunction to enforce a decision that's pending appeal. The way I always saw things, the decision stands until it's overturned or upheld. But obviously we've got to go further and seek an injunction in order to enforce our decision and now the cease and desist order. But I would like to ask Mr. Zender whether his client's, well, why his client hasn't ceased operations, particularly after the cease and desist order.
Madam Chair.
Yes, sir. Ned.
Not that I have to answer this question, but to answer the question, they're undertaking an as of right use. As the building inspector said in his letter, and this is what we've appealed. It has come to my attention that you are continuing to use the property as a contractor's yard. There's no permissions required. This board overturned the prior decision of the building inspector. We appealed the decision. It's under appeal. As I think as Andy correctly said, if the town or any, and this is up to the selectmen, want to seek a preliminary injunction to enjoin the operation during the pendency of the appeal, we'll contest it. And then the parties can go to court and they can demonstrate, likelihood of harm, irreparable harm and likelihood of success and all the things that attorneys will present at that hearing. But I've got a client that owns the land. I've got another client that's operating a business on that land. They depend on that land to operate their business. And if the town or anybody else undertakes an unlawful activity to shut them down, there's going to be a damages claim. So, I don't think this is for this board to get upset or take it personally. This is an important issue. We disagree as to the application of the law. We disagree as to what the board did, and it's in the courts. So I think creating an emotional question out of this is not really appropriate. You have counsel, you have a board of selectmen, you have a town administrator. You certainly can communicate with your counsel and you can make your own decision as to whether or not you think the town should undertake preliminary relief. But I don't think it should be done based on emotion. It should be an evaluation of the facts and the law and whether or not you think that. I can tell you in contravention of Mr. Wise's comments, we're not seeking to delay this. I had a conversation with your town council this afternoon about the best way to move this to a summary judgment hearing as quickly as possible. And we agreed to actually undertake discovery in advance of our timeframe to get it done. And your town council, and this is not confidential information. He represented he would turn that discovery around to me as quickly as possible. I told him that we would get out to him a proposed statement of material facts as soon as we could. So we're trying to get this heard. It doesn't benefit my client to have this hanging over their head. So there's a process. I don't see this as a trial. I see it as a summary judgment motion. I think it'll get resolved in months and not years. And that's kind of where we are. So, I fully expect the board will uphold the building inspector, but I don't think you're here to get angry or emotional or anything else about this. It's to treat it as a zoning board. Thank you.
I wasn't being angry or emotional.
I know, Andy, you weren't. I'm not.
And you've answered the next question that I was going to ask to either you or Mr. Reed, which is to say, where is this matter in the courts? And you're saying that there's going to be a summary judgment filed within when?
Okay, Sharon, if I may.
Yeah, sure.
Okay,
I could probably answer this one a bit. I mean, the point is why we are here tonight is that this stands in the way. We have to act on this appeal in order for them to go forward. Once once we are finished, they can then go forward. Now, Ben, you can take it from there.
Yeah, just to further this, we were actually at the point of filing summary judgment motions on the original hearing by this board. But then a neighborhood group filed the request, the board took an action, and then there was a second decision that got appealed. And so we knew that this cease and desist letter was going to come down the pike. I think thankfully your building inspector issued it sooner rather than later. We appealed immediately, but we have to get your decision from tonight issued, filed with the town clerk, filed with the land court. Once it's been filed, then we can have a case management conference with the judge, consolidate all three cases for hearing and set a briefing and argument schedule for the summary judgment motion. So we just need to get through this next step. If you want to overturn the building inspector, I'll be more than happy. But if you don't, we'll just move it ahead. So
one more question, Ben. Is your client operating at this site in full capacity?
Andy, I can't tell you. I can tell you that, I can't drive by without looking at the site. I always pay attention to what's going on going by. They have been delivering and spreading soil and topsoil to grade the property to the previously approved plan to get that done. They intend to plant the trees that they agreed to plant during the planting season. If they are operating, I don't know to what extent it is. But I couldn't tell you. Maybe, you know, some other people online want to tell you what their observations of what's on the site. I do see when I go by 1 or 2 trucks there. In the times that I've gone by, and again, it's not a lot, you know, I'm traveling down Cape for a reason here or there. I don't see a lot of activity there, but there may be some that I don't know about. Andy. And that's the best I can tell you, Andy.
All right. Thank you, Madam Chair.
Sure. Jan,
Well, I have a question and then some comments. Do you want just questions now, Sharon? What do you want?
sure. Either way, the question first.
Okay,
Mhm.
well, I was going to ask it of town council, but I want to expand on this issue of an injunction. I watched the video again of the January 27th meeting, and at that time, town council said that if we overturned the decision on January 27th, that to enforce it, the town would have to seek an injunction. So do you know why? I mean, clearly they haven't done that, right? I mean, do we have any idea why?
I don't think I'm going to comment on that one.
Okay, all right,
Yeah.
okay. I just have comments after that, so
Okay.
why don't you see if anybody else
All
has questions?
Manny, any questions?
No, I don't have any questions, but what I'd like to say is since the building inspector gave Great White the assist and decease, I believe that they shouldn't be able to work there during this time until the court has decided what is what. That's all.
Okay. And Al,
I agree with Manny. I think we should support the building inspector. GW is not in compliance, and the orders of the building inspector should be enforced. Simple as that. I have no questions.
all right. I would entertain a motion to go to findings.
So moved.
I'll make a motion to go to find.
Okay, and Andy will second then. Okay, this is what I have. This is an application under Massachusetts General Law, C40A, S8, appealing a demand to cease and desist dated March 15th, 2022, noting the petitioner is continuing to use the property and demanding that it cease and desist activity and remove all equipment, materials, and storage containers from the site. The cease and desist order was issued after the board ruled on January 27th, 2022 to revoke the applicant's permit on the site. The findings of that decision, case 2202, are hereby incorporated into these findings. The board further references its findings in cases 2113 through 15, when the board ruled on the uses of this property at its March 25th, 2021 and April 8th, 2021 meetings. Based on all its previous findings and finding no new relevant information, the cease and desist order is upheld. Questions on those findings?
I'll make a motion to accept the findings.
Okay, I need a second.
Second,
Jan seconds. All in favor, Jan?
aye.
Andy?
Aye.
Nick?
Aye.
Manny?
Aye.
And Sharon? Aye. I don't think I need, then I think that's it, because we don't grant a permit. So I think that's the end of those.
Karen,
Yes.
this is what I can do if, you know, if you all get that decision to the town clerk as quickly as possible, I promise I won't wait the 20 days to appeal. I'll file it right away.
Okay. All right, we'll get that as soon as we can. Chris is still recovering from some eye surgery, but we'll
Could I ask
get it in the next day. Yep.
Could I ask a question, Sharon?
Sure.
Does Attorney Zender have access to all the letters, the emails that we got from abutters? Because they clearly show activity far more than what Attorney Zender, does he have access to those?
They haven't been sent to me.
Okay.
Yeah. So
Mhm.
Did you say they have or they haven't?
they
or
have not.
It's not done. I don't know what the law is. Okay.
Okay.
If I may, Sharon, look, if I were to make a request of Chris for the
Mhm.
correspondence, she would send it to me. I really try not to burden her.
Mhm.
You know, the
Right.
letters, I think the letters may be important in the land court appeal,
Yes,
but
yeah. I
not
think
for
that
this
the
purpose.
letters will probably all be part of the letters, and the
Yeah.
photographs and everything that we were sent is probably part of the court case.
Okay, right.
I
Thank
would
you.
think, Mr. Reed, would that be your understanding as well? That,
It would, but we are not actually parties to the land court appeal.
okay.
Mm. We're not appellants because we're not aggrieved by your decision. We agree with it. So
Right, right.
we're offering our assistance to town council if we can be, either as witnesses or with evidence, but we're not
Okay.
parties yet to the case.
Got it. Okay. All right.
Thank you all.
Thank you.
Thank you.
Thank you.
Thank you. Good night.
Good night. Thank
Good
you.
night.
Yep. Chris,
Yes.
did we have minutes from the last meeting that we needed to approve?
Sure we did.
I thought we did. Mhm.
That April 28th?
April 28th.
Yeah.
April 28th. Okay. Do I have a motion to accept the minutes of April
Yes.
28th?
I'll make a motion to accept the minutes of April.
Second.
28th.
And Al will second. All in favor? Al,
Aye.
Andy,
Aye.
Aye.
Manny, aye.
Aye.
Nick, aye.
Aye.
Dan, aye. Sharon,
aye.
aye. Okay, we have done that.
Oh, my God.
Mhm. Okay,
Okay, can I ask one question?
sure.
Somehow there were several voices going on at one time. Am I to send Ben all the letters and?
No, no,
No.
no, no.
No.
Those letters are part of the
That's
part of the
our-
record and will
Okay.
be important in the court case. But they are, you do not have to send them now.
Okay, thank you.
Mhm. Yeah. But, okay. I will send you over these findings and we will, I mean,
What do we have coming up for the next meeting, Madam Chairperson?
We have one interesting case.
yes,
Okay.
The Wellfleet Motel is originally
Okay.
wanted to have a food truck, but then he's changed the terminology of it to a food, like an auxiliary food equipment. And I had the opportunity to talk to Joe Capella from the fire department. Fire department gets very.
Chris, I think we're going to get into too much that we might,
Okay.
we shouldn't be talking about.
Okay,
But
okay.
yes, we have the Wellfleet. We certainly have that one. Do we have anything else coming? So we have that one to go site visit.
I think we have two.
Okay, so
Turns
we'll
out
have a site
together.
visit in 2 weeks.
Yeah,
Hey, excellent.
Yeah, we'll get to see each other in person again.
And Al,
okay.
Lord only knows.
Perhaps. I will be in Philly for a week, but I will be back in 2.
Okay, well, then you'll probably be there. We
Yeah.
don't have this meeting next week. It's the
All right, so-
26th.
I guess I'll make a motion to adjourn the meeting.
Okay, and I need a second. Al seconds, all in favor?
Aye.
Aye, aye. Okay.
Aye.
All
Good night,
right,
everybody.
aye,
Good night,
aye.
everyone.
Good night.
Night,
Good
everyone.
night, thank you.
Night, night. Bye-bye. And Chris, you can turn off the recording.
Yeah, will do.